Mr. Chairman, you're live.
We'll call this meeting to order. This is your Corporations Committee. Will you please take the roll?
Representative Brown,
Excused.
Representative Locke,
Present.
Representative Heft,
Here.
Representative Johnson,
Here.
Representative Lucas,
Present.
Representative Webb,
Excused.
Representative Weber,
Here.
Representative Yin,
Excused.
Chairman Knapp.
Here.
Chairman, you have a quorum.
Thank you. All right, this is our busy time of the year, so we're decimated sometimes with people presenting bills, and I was gone for the first part of this one. So as I understand, we were left off in public testimony. And who did we leave off with?
We had heard the senator and.
In the banking
The
division.
banker. Now, we might want to finish with him just to make sure there's no questions remaining.
Yep. Okay, yeah, if you want to go ahead and come up, we'll kind of continue. And
We'll just make sure that maybe that there's no extra questions, Chairman, possibly. I'm not sure we finished.
okay. Is there any other comments that you have? And I think to be clear, we'll probably stick to the bill. The amendments, I think we'll kind of look to the future for those. So we don't need as many comments necessarily on amendments today. If you just have any more that you want to add to the bill.
Great. Thank you, Mr. Chairman. Jeremiah Bishop, State Banking Commissioner. Just the bill, I think I made all the comments I had on Monday. We worked with the blockchain committee during the interim. It is kind of a cleanup item. We worked through the transition from a speedy to a trust company. I think that's all cleaned up and we're okay with that process. We'll make rules on that process. And then the other items were just more technical changes to the accounting. Like I think I described on Monday. I won't repeat those comments just since you're busy, but if there's any other questions that you had, I think that was all that was left, was see if there's any questions.
Thank you. Questions from the committee? All right, thank you very much. Okay, was there any members of the public that would like to come forward and speak on this bill?
Mr. Chairman.
Go ahead, Mr. Lindholm.
Thank you, Mr. Chairman, members of the committee. My name is Tyler Lindholm. I'm the State Director of Americans for Prosperity here in the state of Wyoming. I wanted to advocate in favor of the legislation, and I think it is a good piece of legislation. Options are always good, especially when we're dealing with the financial sector. Your legislature, Mr. Chairman, and members of the committee has done a significant amount of work over the last 8-9 years in this space to attract different companies, and it has proven to be fruitful. There are companies now all over the state of Wyoming that do deal in the financial services space. In particular, in regards to the legislation, when we're talking about special purpose depository institutions, it's a very novel type of institution that only exists in the state of Wyoming. That currently, I believe, as the commissioner testified, has 4 entities that are currently operating in that space. 2 more active than others, and that's been a positive and net good. What this legislation does is it provides the opportunity for that special purpose depository institution to be able to transfer itself into a type of trust company. And Mr. Chairman, if I could speak very briefly about the amendment.
If you'd like to, I don't think we're going to handle the amendment today,
Okay.
but if you'd like to say some words on it, you can.
I'll just be very quick, Mr. Chairman, and this has to do with what's happening at the federal level. When I saw the amendment, the initial intent of the amendment is just to provide another option. Options are good in financial services. We attract businesses, so forth and so on. I do think it is important, Mr. Chairman, when we look at a special purpose depository institution going to a traditional state chartered bank, I do think that it would behoove one of the committees or an individual in the long term to look at the reverse also. And that has a lot to do with stablecoin legislation that is currently moving its way through the federal level. where that stablecoin legislation would essentially require a traditionally chartered state bank to look at being a special purpose depository institution. So the reverse methodology might be handy also. I'm sure that would be a lot of extra work. However, Mr. Chairman, members of the committee, Wyoming is currently #1 in the world in this regard, and I think it behooves the state to stay on top of it. And with that, Mr. Chairman, I'll stand for any questions.
All right, any questions? Seeing none? Okay, thank you.
Thank you, Mr. Chairman.
Hello, please introduce yourself for the record.
Hello, Mr. Chairman. My name is Matt Kaufman. I'm an attorney with the law firm of Hathaway and Coons here in Cheyenne. I'm also Governor Meade and Governor Gordon appointee to the Select Committee on Blockchain. I've served on that committee since its inception. Mr. Chairman, I'll be super brief. I just wanted to provide some quick testimony. I was part of the working group that worked on this legislation during the interim, obviously in support of it. Myself and my firm have worked with 3 of the now soon-to-be 5 chartered SBDIs going through the process. And what I just really wanted to call to the committee's attention is, obviously, with the new administration, President Trump has prioritized digital assets. We are seeing an explosion of interest in this charter and in Wyoming with respect to a lot of the legislation that's been passed over the last several years. I view this bill as a competitive advantage to keep Wyoming at the forefront. We're repeatedly hearing about charters looking at now Connecticut, even New York, Utah, South Dakota for different types of fintech, financial technology charters. And in my mind, this bill really helps carry through what Wyoming started and maintain both the attractiveness, but again, the competitiveness of the charter. You know, specifically with things like the custodial fee. You know, some of our clients have worked through modeling to even show that right now, under that custodial fee, we're more expensive than states like New York with respect to that fee. So again, it's not anything that's, I think, controversial in any way, shape, or form. We've learned a lot over the last number of years sort of enacting this and working through this legislation. I think this is a really, really great step forward to keep these companies that are here investing capital, hiring people, and building businesses in Wyoming to keep them coming and keep them here. So happy to answer any questions, but just wanted to provide that brief statement and my support for the bill.
Thank you. Any questions for Mr. Kaufman? All right, thank you, and thank you for your work as well.
Thanks, Mr. Chairman.
All right, any organizations that wish to speak on this? Welcome.
Good afternoon, Mr. Chairman, members of the committee. Scott Meyer on behalf of your Wyoming Community Banks and the Wyoming Bankers Association. We just wanted to let you know that having worked with Senator Rothfuss and looked over this bill, we stand in support of it.
All right, thank
Stand
you.
for any questions.
Any questions? All right, thank you. Matt, is there anybody online for this particular bill?
Mr. Chairman, there is not.
Okay, thank you. With that, I will close public testimony. Committee, what's your pleasure? Okay. Vice Chair Locke with the motion, second with Representative Johnson. All right. Are there any proposed amendments to the bill? All right. Seeing none, we are taking roll on Senate File 95, Special Purpose Depository Institution Amendments.
Thank you, Mr. Chairman. This is a roll call vote on Senate File 95, Special Purpose Depository Institution Amendments. Representative Brown.
Aye.
Representative Locke.
Aye.
Representative Heft.
Aye.
Representative Johnson.
Aye.
Representative Lucas.
Aye.
Representative Webb submitted an absentee vote of aye. Representative Weber
Aye.
and Representative Yin submitted an absentee vote of aye. Chairman Knapp.
Aye.
Chairman, you have 9 ayes.
All right, and of course, we'll look at those amendments for interim, but With that vote, Senate File 95 does pass the committee. Thank you. Thank you, Senator. Okay, next up, we have Senate File 95, third-party filers. Oh, I'm sorry. Did I jump ahead? Oh, I'm sorry. Senate File 55, third-party filers. And with that, Secretary of State's office, could you please come up and go over the bill? Go ahead and introduce yourself for the record.
Thank you, Mr. Chairman. My name is Colin Crossman. I'm the Director of the Business Division. I expect that the Secretary should be along here momentarily. He's probably on several other bills. So I will start by just going through the bill since there's nobody here to present it, if that's all right. All right. Let's see, that's 55. May have to call it up because I was expecting.
Oh, you're fine.
Here we go. All right. All right, so Senate File 55 is third-party filers. It is going through page 1. It starts off creating these new sections, and here we go.
Right on cue. Right on cue. Mr. Secretary,
Well-
welcome. We just started.
Thank you, Mr.
So
Chairman.
Senate File 55, third-party filers. Engrossed.
Well, Mr. Chairman, this is one of the bills that came out of the Business Fraud Working Group. You know, I think that in terms of bills that are going to get a lot of coverage and are very prominent, the foreign ownership bill is a big one. But this one is really at the heart, Senate File 55, of what we're trying to do in effectuating an attack on this fraud. And I use that word very intentionally because we're attacking the fraud at the Wyoming Secretary of State's office. One of the things that, you know, I think that set our administration off from my predecessors is that we're not, you know, Panama Papers comes out and the secretary at the time kind of said, look, nothing to see here. The other one, what was the other one?
Oh, Panama Papers, and then, what, you mean the North Korea one?
No, the other big release. And my predecessors, in a way, Panama Papers, have you know, not attacked the fraud as vigorously, I'd say, as our administration. I'm really proud of that. So we present to you Senate File 55, which is really getting at these third-party filers, people filing on behalf of entities. And you'll see there on page 1, this definition. We have a little bit of wind-up here. Is used in this section, third-party filers means a natural person who receives compensation to file documents with the Secretary of State on behalf of one. How do I turn to the next page? Okay. One or more business entities and who is not a direct employee, shareholder, director, member, or otherwise under the direct management or supervision of the business entity on whose behalf the documents are filed. And then it says a third-party filer may include an employee of a commercial registered agent or another business entity. Now, I'm going to turn it over to Mr. Crossman to talk a little bit about why that's important here as we move forward. Then it says a third-party filer shall not include an attorney who is a member in good standing of the Wyoming State Bar or a person holding an active certificate of certified public accountant under the laws of this state. Now, this came in committee during the interim, this sort of carve-out for attorneys and accountants from the provisions, the requirements of the bill. I oppose this amendment. I still do. I think we should take it out. I think we should be across the board on this definition of third-party filers and not have this exemption for attorneys and accountants. And look, attorneys, accountants, you know, there's bad ones, there's good ones, there's a lot of great ones, but, you know, there's also, we can't just assume everyone is a great apple, and I think that provision kind of does that. Yeah, I mean, they have sanctions all the time, the Wyoming State Bar does, so I think we should take that out. Then B, a third-party filer shall register with the Secretary of State after filing 10 documents with the Secretary of State in 1 calendar year. So there you have that's when you hit the point where you're gonna have to certify yourself with our office. And what we're trying to attack here, one of the things is our concern that some of the people signing these documents may not be real people. And so once you file 10 of these documents, you're going to need to certify with our office. If a third-party filer files 10 documents with the Secretary of State in 1 calendar year, no further filing shall be accepted from the third-party filer unless the third-party filer is registered as required under this section. The Secretary of State may reject any document filed in violation of the subsection up to 90 days after discovery of the violation. So this is one of the things that's going to require a system adjustment. We'll talk a little bit about that as we proceed through our presentation of the bill, is we're going to have to be able to track when somebody hits that point of 10 documents. Okay. And then subsection C, a third-party filer shall obtain a registration by filing an application with the Secretary of State. So now we're really getting the follow-through here. I like when bills have the follow-through a little later in the bill, and this is one of them. The application shall be notarized. You know, the pitch was really thrown on that first sentence. The application shall be notarized, executed, and sworn under penalty of perjury and contain the following information: the third-party filer's legal name, the third-party filer's home address, phone number, and email address, if applicable, the third-party filer's business address, phone number, and email address, a copy of the third-party filer's valid state-issued driver's license or ID card. And I know this reads, I mean, I'm a less government guy too. I know this reads a little bit prescriptive, but the policy choice before you is, are we really going to take on this fraud? And I'm afraid if the answer is yes, and for me, I'm there, the answer is yes, that there are some things we're going to have to do that require some verification from government. And that's really where the pitch is thrown. Now, this is much more limited than the CTA, which, by the way, and maybe we'll talk about this in our interim topic discussion, is back on. The deadline now is at the end of March. So now, what do we have? Four starts and stops since December, since Christmas Eve?
At least 4.
Yeah, at least 4. So it's back on now. And maybe we'll talk a little bit about that at the interim meeting. But this is much more limited than that. And I've raised my concerns about the federal CTA and every business filing their beneficial ownership. This is about third-party filers that are filing on behalf of businesses. Now, subsection D, every applicant for registration in the section shall pay a filing fee as set by rule adopted pursuant to this chapter. The fee shall be designed to recover the cost of administering the provisions of this section relating to third-party filers and shall not exceed $50. So it's a little bit of a rulemaking there to set a cap, and it's capped at $50. E, a registered third-party filer shall notify the Secretary of State of any changes to the information included in the third-party filer's application. Under subsection C of this section is required by rule adopted pursuant to this chapter. It's very important we get those updates. We don't want to create some loophole where somebody's able to file something initially and then they make a change where they say that this is something that had changed and then they didn't need to report it originally as their argument. So that's trying to get around that loophole. F, there's the penalty here. We are really in the post-pitch stage of the bill. The Secretary of State may impose a civil penalty not to exceed $500 for each violation. G is the confidentiality, so important. That we continue to maintain that. We're holding the third-party filer registration records confidential, and of course, there's a driver's license there, so we take that very, very, very seriously, and we will hold those records confidential. We're very good at that at Secretary of State's office. We have the voter information. We manage YOReg, the voter registration system, so it's something that we're very accustomed to in the Wyoming Secretary of State's office. And then section 2, we've got the rulemaking. Now, section 3 is where we get to the appropriation. This $150,000 appropriation, beginning with the effective date of this section and ending June 30th, 2026. We'll speak to that in my testimony for the bill and really get into that a little bit. And then section 4 is the enacting date of January 1st, 2026 for all except as provided in subsection B, and then sections 2, 3, and 4 being effective immediately, the appropriation and the rulemaking authority as we ramp up to get this moving. There is considerable implementation on this bill. So obviously, it's very important we have that ability to set the rules, the procedures in place, and then also receive the appropriation for the systems change. Mr. Chairman, with your indulgence, I'd like to move into testimony in support of the bill and a little bit more background on the appropriation. Is that okay?
Yes, go ahead.
Well, thank you, Mr. Chairman and members of the committee. I'm Chuck Ray. I'm the Wyoming Secretary of State. To my left, we have Colin Crossman, the Director of our Business Division. Again, this is one of the bills that came out of our working group, Senate File 55, third-party filers. And it was one of the ones we asked for drafting. I think it really effectuates a key purpose. And Mr. Chairman, as you remember from our discussions at the first interim corporations meeting in April 2024, and again throughout the interim, and just to remind the rest of the committee that was not with us, the intent of this concept was really to ensure that serial third-party filers, that is third-party filers that file documents with the Secretary of State's office on behalf of another entity, are verified as real people. And a little bit of the provenance, again, we had asked for an interim topic in 23 on our taking the oath of Secretary of State for a business fraud interim topic in the Corps Committee. Unfortunately, came up short on that one. And then 24 asked for it again. And what came out of that first meeting in Lander was the creation of the Business Fraud Working Group. One of the bills that came out of that, of course, is Senate File 55. Now, as we talk a little bit about third-party filers, this bill draft would require third-party filers who receive compensation from business entities to file documents on their behalf and who file 10 or more documents with our office to register with our office and provide both a notarized sworn application under penalty of perjury, attesting that the third-party filer is a natural person, as well as provide additional documentation, including the third-party filer's home address, phone number, email address, and driver's license. Now, Mr. Chairman, with your indulgence, I think Mr. Crossman wants to talk a little bit about the CRAs and how they interact with the bill.
Mr. Crossman.
Thank you, Mr. Chairman. So this is a separate regulation that will now sit on top of the regulations we have for the CRAs. CRAs are regulated already. We have a CRA is an entity that files that represents the entities that are filed in our office if they do not have an address in Wyoming, or if they do and choose to have this a commercial registered agent rather than use their business address or personal address for their service of process. So the CRA effectively is the agent for service of process that is a third party that is hired, and we regulate those pretty strictly because of the situation that if you miss service of process, then your company could face a default judgment and have no way to recover from that. So having a CRA or a commercial registered agent that is on top of their files and everything is extremely important. This is a separate thing that now goes toward people who are filing documents with our office that are not an employee of the organization on behalf of who's. So if you have an LLC and you file it, or you have an employee file a document with our office, that's not a third-party filer. That would be a first-party filer. If you hire someone to file the document with our office, specifically signing that document, because that's filing, not delivering it. So the postman is not a third-party filer, okay? The DHL, the FedEx is not a third-party filer. This is the person who's preparing, executing, and delivering the document to our office. We allow for a registered agents or anyone, the entity may designate an individual as an authorized individual to execute documents on behalf of the organization. That authorized individual, if they are an employee, would not be a third party employee of that organization. If they are an employee of some other group, that's a third party. So that person's signing.
So I have a question. So even if it's somebody that they designated, you consider them a CRA?
Well, thank you, Mr. Chairman. No, not necessarily. A CRA can be the third party, but doesn't have to be a CRA.
Okay.
So often, for instance, we have CRAs that will go through the process of incorporation and organization of the various entities, and they will execute those documents in their name. Now, as an organizer or an incorporator, you are not liable for the company. That's in our statutes, that an organizer or incorporator can easily be a third party, and that is fine. And that person does it with us, signs the documents, and hands them over to the new entity. That person would be a third party. Now, if you, Mr. Chairman, were to come to our office, sign a document for your own corporation, that's not a third party. Similarly, future documents filed in our office can be signed, many of them can be signed by such an authorized individual, such as annual reports, address changes, and other such documents can be signed by that authorized individual who is not an employee of the company on behalf of whose those documents are being filed for. Those are the filers. A person who, like an attorney or an accountant who, let's say you're doing your annual taxes and they hand you your annual report form that needs to be filed with us. They prepared it, they filled everything in, but they're not executing that. You're signing that document. The CPA, the attorney, that is not a third-party filer. You are filing it for yourself because you're attesting to it. So that is, I think, a bit of confusion that may have been there, but that is where these things get a bit of difference. A CRA, their only statutory duty is to exist for the purpose of receiving service of process. They often offer other services, such as they will accept other mail. Sometimes they offer a virtual office or even a real office that you can go in and use like a hot seat. Sometimes they offer phone services, internet. They offer all these other ancillary services, but for the purpose of being a CRA, it is only that they are here to accept service of process. If they are filing documents on your behalf and executing them on your behalf, that is when they also become a third-party filer. So these two things can coexist, but they don't have to. There are plenty of CRAs that do not offer that service, and they would not be third-party filers. There are CRAs that do offer that service and would be third-party filers, and there are people who are not CRAs who do this, and they are third-party filers, but not CRAs. And I think that hopefully is somewhat clear.
I'm with you.
You have anything to add?
I think that goes pretty
Okay.
deep into it, yeah.
Thank you, Mr. Chairman. And again, want to reiterate my concern with the language on page 2, lines 6 through 10. Having these carve-outs, I was never a big fan of that for attorneys and accountants. You know, there's great ones, but at the same time, I think we should just make a decision on up or down on whether we're going to have this requirement, in my opinion. Now, yeah, let's talk a little bit about the appropriation and the administration of the bill now. You'll note that this bill is engrossed, reflecting the appropriation to accommodate these changes to our system and its implementation by our office. During our committee meetings on the bill in the interim, we had discussed its implementation, which will require a new module for third-party filer registrations to be developed into our existing software WIO suite, including a form for recording required details and payment. Additionally, automated notifications and reporting will need to be created to manage filers approaching or exceeding the 10-document threshold, prohibiting further filings without registration. And we're going to need to align that. So if someone, uses their middle initial on one filing and then not the other, we're going to have to really find a way of keeping track of that, which isn't always easy. During the interim, because there's a lot of these filed in our office, during the interim, in this bill's infancy, I know that I believe it was Senator Landon added an appropriation of $100,000 based on our preliminary estimate. In speaking with our tech division at our office, we do have a revised estimate given more time to get into the particulars of the change requirements, that the cost to perform these changes may be up to $150,000. And so this bill was amended, which you will see in section 3, replacing the $100,000 appropriation with $150,000. And that's very important that we have that ability to implement the bill. Mr. Chairman, with your indulgence, I think Mr. Crossman wants to speak a little more to the appropriation.
All right. Thank you, Mr. Chairman. So the appropriation is designed to allow us to build out the software components that would allow us to track this because, as the Secretary said, we'll have to be tracking all of the signatures, and if the signing entities of each document, making sure that they're in there. We have a large amount of that is done with the initial filings, so there'll be some modifications to the system to pull that out and make that available to us to see. So that's already in the system, but we have to get at it. And then for paper filings, we'll have to have that same system be added in so that when people are processing paper filings, they'll be able to do that and also analyze and then flags when people have hit the limit, so that we can track it. And as I said, since this is going after people who are executing documents and filing them with us, that is the trigger. So that is what we're tracking.
Thank you, Mr. Chairman. With that, I'd like to talk a little bit about an amendment that has been brought to our attention that some folks are looking to bring. Mr. Crossman, do you want to walk through the amendment and some of our concerns with it? Right here.
Mr. Crossman?
Thank you, Mr. Chairman. So this amendment that we were provided, as you can see, I don't know if you have a copy of it. It starts out basically changing the definition of third-party filers to talk about certain incorporators and organizers, and going, if you look throughout, that's effectively what it is doing. It is altering the definition, I believe, to only these initial incorporators or organizers, which is not, that gets at some of the concerns that we have, people who are organizing and incorporating, but that's not the full concern. The concern is the people who are executing documents on behalf of the entities that aren't part of the entity. And I don't, to me, it reads as if they don't really understand what the bill was for. And a person who is preparing a document, sending us a document, but is not signing it, is not a third-party filer. And that it's only the person who is executing it. So if you are like an attorney who is providing this document to your client, and they're signing it, and then the attorney is taking it back and sending it to us with a check from the attorney's office, that's still not third-party filing. That is scrivener, that is preparing, but the attorney is filing it on behalf of the client, not on behalf of the attorney's signature, which would be if they were signing it and filing it. So there's a difference there. So I don't believe this really gets at that issue. In fact, I think it completely removes that problem. And we think that we need to actually get at those individuals to make sure that, to go back into history, some of you may remember 2008 and the mortgage crisis. It was discovered that several banks were signing mortgages without real people, right? What happened? Those mortgages were null, and void. So what happens if we have someone who is executing documents that isn't a real person? They're just making a fictitious name and signing documents. Well, that's a problem. We need to make sure that people who are executing documents with our office are real people, or at least somehow related to the entity, so that we can make sure that that doesn't happen here.
And the bottom line, Mr. Chairman, is we just don't think the amendment is, if somebody else is filling out this information on a website on behalf of themselves and signing that information for themselves, it's not getting to the heart of the bill. The bill is not applicable to that. And so that's why we just oppose the amendment. We want to keep this clean. We had a long interim process, and certainly, I know we continue to work the bill, but this really could have been brought out during the interim, and I just think to come in at the last moment on something that's going to muddy the waters, on something that we don't believe is covered by the bill, is just the wrong way to go. Thank you, Mr. Chairman.
Thank you. Are there any questions? Representative Lucas?
Thank you, Mr. Chairman. Mr. Secretary, Mr. Crossman, always a pleasure. I have a few questions.
Yeah.
I don't have to barrage them all, but a couple of them are really easy. Remind me what CTA is?
Mr. Chairman, thank you for that question. The CTA is the Orwellian named Corporate Transparency Act. And I don't like to use the name because it's written by very ideologically driven people that are good at using language in a certain way. I mean, people say Corporate Transparency Act, we all want transparency, but I mean, we also have a tradition of it goes back to the English common law of striking a balance on these issues. And what they did in 2020 is the Congress rolled into the NDAA, the National Defense Authorization Act, this CTA, and the heart of the CTA is a requirement for all businesses in the country, in the United States, that are registered in the country, foreign or domestic, to register their beneficial ownership. It's a big deal to do that, and is a big change. President Trump, in his first term, vetoed the NDAA that had this in there, and the Congress, believe it or not, overrode his veto. It was in 2020 during COVID. It kind of, I think, got lost in all the coverage on the things, and there were a lot of things that went through the Congress. And President Trump took a stand against it, as he continues to do, but unfortunately it was overrode in the Congress. Fast forward here to 2024, when the CTA was set to be implemented, the deadline for existing businesses was at the end of the year. There was a federal case in the Supreme Court, in the what was it, Seventh Circuit? I always get confused by these. Fifth Circuit. He's my circuit guy. He always gets me right on the numbers. And the Fifth Circuit that came through in early December that enjoined the CTA in early December, when only in our conversation with FinCEN, which is this sort of quote unquote agency or pseudo agency propped up to implement this thing, implementation nationwide with less than 1 month to go, was it 9%? 9% had sort of complied with the act with less than 1 month to go after it had been in place for 4 years that they could file. So that was enjoined in early December, so the filing requirement went away. Then I'm rolling in from lunch 2 days before Christmas, not Christmas Eve, but it's the day before Christmas Eve. And some appeals court undoes the injunction 2 days before Christmas, with like 4 or 5 working days until the original December 31st deadline. Now, FinCEN did move that back, I think, in their infinite wisdom, like 12 days or something, and said, okay, we're going to give an extra 12 days, 2 days before Christmas. Then, like, it was one day after Christmas. It was the Thursday or Friday.
It was the very next day.
Yeah, it was the day after Christmas. That was undone. And the requirement went away again. And then what happened?
Well,
Mr.
then
Crossman?
in the Supreme Court, about 2 weeks later, the Supreme Court put it back. Undid it, but then it was another. This is why it's so complicated. On the 9th of January, unbeknownst to anyone, the second court put an injunction in place, and then a week and a half later, the Supreme Court stayed the injunction from the Fifth Circuit, forgetting about the one on the 9th, so that everybody thought it was back on, but it wasn't. So it flip-flopped again, and now.
And now we've
now
got
back on.
this deadline back. Now, we have a whole sheet on our website where we go through it, but the deadline is back now. I have since signed a letter with 13 other Republican secretaries of state asking the Trump administration to continue to fight this. President Trump, of course, vetoed the original bill and has continued to stand strong against this, but it's very concerning. And so we need to continue to monitor this. There's a lot of uncertainty out there on this. I filed an amicus brief with Senator Lummis with our position that the injunction should have stayed, meaning that compliance would not be required as this proceeds through the courts. The whole point of an injunction is that it takes time to hear the case. And so they'll often enjoin pieces of legislation so that they are not implemented pending the litigation, because once people file, that data is there. And then.
So I'm going to interrupt real quick. Has your question been answered?
Mr. Chairman, yes, thank you.
All right,
I was
thank you.
thinking CTA stood for Chicago
right.
Transit Authority, and I
Follow
am
up.
clarified. Yes, thank you.
All right.
Is it fair to say Mr. Secretary or Mr. Crossman, that currently certified registered agents, that's CRA, right, do not provide identification when they register with you?
Mr.
Do they?
Secretary?
Go ahead, answer that.
Thank you, Mr. Chairman. So the CRA itself, the responsible individual for the CRA does provide us with identification, and their application is notarized. However, that is basically just the owner or managing partner of the CRA. If a CRA employs 20 people, those individuals are not known to us necessarily. So for the purposes of this bill, those individuals who are doing who become third-party filers by doing the things that filing entails, which, as I have said, includes executing the document on behalf of the entity that it's their client, would need to register with us as third-party filers. Those employees that do not take that last step, who are maybe just handling documents, handling mail, whatever, would not need to register with us.
Okay,
Follow up?
well,
Go ahead.
different question. So I'm looking at page 2, line 6 through 10, this third-party filer shall not be an attorney and shall not be a CPA. And that means that no attorney or CPA could be a third-party filer, even if their business is unrelated, or, that they just happen to be a CRA also.
Mr. Secretary?
Yeah, Mr. Chairman, you're correct on that they're exempted from the requirement. I know Mr. Meyer's back there, and appreciate Mr. Meyer. We work with him. We sometimes disagree, sometimes agree, maybe a lot disagree, but sometimes agree. I enjoy working with him. He's very passionate about this provision. I, again, would prefer for it to go. I think we should just be clean on it. We're not begrudging any attorneys or CPAs, but we just want to be clean and consistent here. And that's why I'm for taking that out and removing that exemption.
Yeah, it just seems a little,
Follow
Mr.
up?
Chairman, thank you. Yeah, it just seems a little messy and kind of unnecessarily restrictive that no attorney who's in good standing could be a third-party filer. It's
Well-
just odd to me.
Well,
Mr.
exactly.
Secretary?
Thank you, Mr. Chairman. Excuse me on that. There are bad attorneys, and we're not begrudging anybody, but there are attorneys all the time that get sanctioned, and, not that, it happens all the time. And so I think to have this blanket carve out, and to say, well, if they maintain their status, that means they're great to go. I don't agree on that, and I think it should be removed, but thank you.
Good. Any other questions? Vice Chairman Locke?
Thank you, Mr. Chairman. I'm sorry, I might be a little thick here, but I want to just double check this. Third-party filer. So I thought, and then maybe I misunderstood, that if a CRA is filing on behalf, that they're already registered and regulated by you, correct?
Mr. Secretary, Mr. Crossland?
Yes, thank you, Mr. Chairman. The CRA entity and the owner of the CRA company is registered with us, not necessarily the specific individual who is executing that document. And that's what we're getting at. And without naming any specific entities, for instance, the processing of documents inside a CRA can be automated. That's fine. That doesn't create another human doing something. They can also be outsourced to other entities. And it's we need to know that the person who is signing the document that is on file with our office is a real person and has some connection with somehow. So, I mean, we don't want to have a situation where we find out that, there are documents that have been filed with our office where the person either isn't real or isn't authorized to do that signing.
Follow up?
Please, thank you. And so, thank you, Mr. Chairman, and just making sure, so what you're saying is the CRA files documents, may do it automatic, whatever, but an individual inside working for the CRA could be this third-party filer.
Yes, Mr. Chairman, thank you.
Thank you.
Yes, the answer to that is yes, the CRA could file the documents. If the CRA, the individual who is the registered CRA in person on our who is that, if they execute a document for a customer, they still would be a third-party filer. So that's, it's the two, we're taking apart the two things. The CRA is now with this is limited to the CRA duties in statute. And if you are executing documents on behalf of your clients, either you or through you, your employees, or connections through a through a true third party, such as you contract with another company out of state to do it, those people who are executing the documents are the third party filer. A CRA who does not take that step of signing the document on behalf of their client and is just handling the documents and providing them to us, but the client has signed them, that is not a third-party filer.
Thank you.
And
Mr. Secretary, did you, okay.
Mr. Chairman, yeah. Mr. Chairman, one of the things that we're concerned about as employees at some of these CRAs, that we're concerned are not real people,
Sure.
so-called employees. So we need to dig into that. We don't have proof. And that's what we're trying to get out of this bill, is having a mechanism to identify that.
So my question is, why is it 10? Why is 10 the magic number? To me, if you're going to track that, why go so far as 10?
Thank you, Mr. Chairman. I believe the 10 figure was just picked because that is the same number that if you are a registered agent and you have 9 entities, you do not need to register as a CRA. If you have 10 or more, you do, even if you are not representing other people. If you have 10 LLCs, a normal person could have 10 LLCs. That's fine. If they are acting as their own registered agent, they would still have to register with us after 10. So that 10 figure, I believe, was picked from that.
Okay, thank you. Any other questions? All right, thank you for your testimony. Are there any other agencies here to talk about this? Anyone from the public? Go ahead and come on up. Please identify yourself.
Mr. Chairman and members of the committee, I am Kelly Manchester, president of Corp One, a commercial registered agent with physical offices in Wyoming, Delaware, Colorado, and New Mexico. I am here on behalf of the NPRRA, which stands for the National Public Records Research Association. We are here to be a partner of the Secretary of State's office to help fight fraud. NPRRA members are companies and individuals who offer services related to documents stored in public records maintained by federal, state, and local government agencies. Our members search, retrieve, and file documents, and serve in certain corporate capacities such as registered agent. Membership composition ranges from small businesses of 1 to 2 people, serving specific local jurisdictions, to national companies like mine with hundreds of employees, to international firms that obtain documentation from sources around the globe. NPRRA members provide a wide array of services to the legal community, the financial industry, and the general public. Our website is nprra.org. Please allow me to share some important talking points on this bill, third-party filers, developed by many key industry players, such as Wolters Kluwer CT Corporation, CSE Corporation Service Company, Cogency Global, Registered Agent Services, Inc., LegalZoom, Capital Services, Universal Registered Agents, and Corp One. But unanimously supported by the entire organization's 150-plus member companies, some of whom are also attending this hearing via Zoom, and may have additional comments or can provide further clarification or answers to questions on these points. It is the employees of our companies who file documents with the Wyoming Secretary of State's office, which is why this topic is so important to us. Our first talking point is that the bill is very broad. Many, if not most, third-party filers, like employees of our member companies, do not sign documents as incorporators or organizers. We may prepare a document, but we send it to the client for their signature prior to filing. Wyoming's Commercial Registered Agents Act already governs commercial registered agents and has penalty provisions. Currently, if an entrepreneur forms a new entity, they must individually serve as the registered agent. They cannot name their company. Let me give you an example. If Sally Smith forms Sally's Bakery, Sally Smith herself would have to be named as the registered agent. In this example, you are getting the information for an individual in Wyoming since they are serving as the registered agent for their company. Alternatively, if we, as a Wyoming service company, hired by a Texas service company, hired by a Texas law firm, hired by a Texas business to form or foreign qualify in Wyoming, this bill is asking us to have the PII, in other words, personal information, driver's license, of that person who signed the formation document along that entire chain. If Wyoming is aware of one or more bad actors, it already has mechanism to go after them rather than putting thousands of our employees' PII at risk when they are complying with Wyoming law. Even the Federal Corporate Transparency Act, CTA, does not go as far as to require the home address of the registered agent filers, which is why FinCEN developed the FinCEN ID concept to protect filers' PII. IDs are obtained after providing PII to a secure system, and IDs are used to identify who filed rather than sharing PII around the world. Point number 2, the Secretary of State will be targeted for hackers, putting thousands of individuals at risk. This bill as written is overly broad and will result in the Secretary of State having to collect and protect the PII of thousands of individuals who are not engaged in any wrongdoing. The database will be filled with highly sensitive PII that is of little use or no use to the state in furthering its furthering its goal to stop bad actors from using false name as incorporators or organizers. However, this highly sensitive PII will be of great interest and use to those hackers. Even databases with strict security protocols, such as Equifax and FinCEN, have had recent data breaches. Who, by point made earlier, has had access to far more than $100,000 to $150,000. The bill's broad scope will hurt Wyoming small businesses as a result of less formations. The bill's current language targets entry-level customer service employees of registered agents, requiring each employee who submits 10 or more filings annually to provide their sensitive PII to the state along with a copy of their ID. Yet these employees, who are often recent college graduates just entering the workforce, serve in that limited role of reviewing filings to ensure every data field is complete and submitted to the state. There is no value to the state to have their personal information, but as mentioned above, the PII of those employees is highly valuable to cyber criminals. Not only does this put thousands of hardworking employees at unnecessary risk of identity theft, but it likely will hurt Wyoming business. Current and prospective employees will be wary of an entry-level job that requires them to provide their PII to the state and obligated to update it. Furthermore, this bill's scope will likely result in less Wyoming formations. No other state requires what this bill proposes. Rather than risking a breach of their employee-sensitive PII, out-of-state attorneys and their staff who are subject to the bill's broad requirements will likely look elsewhere to form entities, as will other businesses. Narrowing the bill as proposed will better address the concern without needlessly burning the state's resources, which could be put to better use. In closing, NPRA has drafted proposed language for your consideration. It has been shared with you. We want to emphasize that third-party filers, aka commercial registered agents, are here as your partners in this process, not as adversaries. Our shared goal is to serve the public by delivering the best possible services. Some key points, if I may. If the bill truly does not apply to those who do not sign documents, since our employees do not, then we would respectfully request that the bill specifically exclude CRAs, because as it is written, it does read that it does apply to every one of our employees, even though we do not sign bills or sign documents. Please also note that the Corporate Transparency Act does not require home addresses in the record. They provided the FinCEN ID to protect the PII of our employees. as also already mentioned, we are already registered as commercial registered agents. As long as we are in good standing, there are those of us who are moral and ethical commercial registered agents do not sign documents. And with that, I know there are people on the Zoom call who are attorneys who would love to answer your questions. Thank you.
Questions? Okay, no questions. Thank you very much for your testimony. Okay.
Good afternoon, Mr. Chairman and members of the committee. Scott Meyer on behalf of my law firm, Scott W. Meyer PC, with offices in Cheyenne and Lander. As an accountant for 40 years and a practicing attorney for 30, whose practice pretty much just revolves around business planning and estate planning, I file several entities. And to answer the question, I think that why 10, I don't know why 10 or more. Why not 5? Why not 100? If this is designed to protect fraud, I don't know what the magic number is. But I don't think that this particular bill does as much to protect fraud as anybody might think. I'm also as a commercial registered agent. I form companies for my clients, and I do it for estate planning purposes or business planning purposes. And if I know them, I serve as their commercial registered agent, so they don't have to worry about it. Whether they are all the time in Wyoming, or maybe they're vacationing or they're sunbirds or whatever, they don't have to worry about it. I serve as that. I already filed my report as a commercial registered agent because I have more than 10. I didn't have to file any documents other than a notarized statement. So this is just going above and beyond. Now the request is that we, as a practicing attorney who's trying to help my clients, I have to file with them something and pay another $50 that says I'm a frequent filer. Yeah, that's what I do. And I do appreciate, I think, the language in there that says excluding attorneys and CPAs. But the reality is that I'm not sure this does anything to protect the fraud. And it does impact those who do work. Now, I think that there are some nefarious outfits out there that can file a bunch of these. But I'm not sure we're not throwing the baby out with the bathwater by saying, here's how we're going to do it, and we're going to limit it to 10. I do sign documents on behalf of my clients with their permission, with their written permission, and I have that, whether it's an annual report, whether it's filing the documents as the organizer. I do a lot of that work, but I do that for my clients because I'm able to do it quick and easy and at a fair price. I don't think this bill does anything other than make it more complicated and take more time and is more invasionary than anybody ever thought. With that, Mr. Chairman, with all the experience, I'm happy to answer any questions about this stuff.
Representative Lucas.
Thank you, Mr. Chairman. Mr. Meyer, pleasure. Question, when you sign documents or form companies and all of these other things that you mentioned for your clients, are you doing that in your capacity as their attorney or as their registered agent?
Mr. Chairman, Representative Lucas, I think I'm signing those things. I serve as their registered agent, but I'm signing them as their attorney.
Okay. Thank you.
Any other questions? All right, thank you.
Mr. Chairman.
Is there anybody else to talk on this issue? Matt, how many people do we have online?
Mr. Chairman, we have 3, possibly 4.
Okay, if we can limit our testimony, if some's already been stated, don't state it again, but welcome and introduce yourselves.
Appreciate it, Mr. Chairman. My name is Stephanie Green, and this is Renee Brower. She is the Executive Director of the Wyoming Society of CPAs, and we are here today to represent our members. I myself am a CPA here in Wyoming. I practice at MHP here in Cheyenne. I am an auditor by trade. We are here in support of the overall bill, but we do want to emphasize that we appreciate the carve-out for attorneys and CPAs. And just want to provide a little bit of additional information for you all as to why we do support that position and would not support an amendment that would add back or take Specifically, we find that adding in the CPAs is duplicative information. And that predominantly is because, much like attorneys, and I don't want to speak for them, but Wyoming CPAs are already registered with the Wyoming State Board of CPAs. And as part of that registration process, everything that provides or supports that we are an actual person, a real person, is provided to the state board as part of the application process. Is reviewed by that board, their executive director and their state board. So as a part of our application and licensing process, we explicitly provide a verification of lawful presence. Included in that, we also provide identity and employment authorization, including either a U.S. passport, a permanent residence card, driver's license card, ID, social security number, birth certificate, numerous items that prove that CPAs prior to being licensed are actual people. And if that is the intent of the bill, that information is already provided to the agency of the state. And rather than including CPAs in this bill, we recommend that the Secretary of State's office find some way to work with the Wyoming State Board of CPAs to be able to obtain or review such information on maybe an audit-like basis. Further, just to point out, all CPAs are required to renew their license on an annual basis. There is a process under our professional rules and regulations where we have to notify the state board of any change in name, address, email address, telephone number, or employment status, and that has to be provided within 60 days. All of those things, had not done, would be grounds for some sort of sanction or termination of our license. So there's already a process in place here in the state to regulate CPAs. We recommend that that process be relied upon rather than adding a duplicative and onerous process for CPAs to be registered.
Great, thank you. Any questions? Representative Lucas.
Thank you, Mr. Chairman. Could you think of any situation where a CPA would desire or need to be a third-party filer or one of these? Yeah, third-party filer is the term.
Yes, ma'am, Chairman, through you.
Yes.
It happens all the time in our profession. So there's probably a mixed bag. CPA firms that maybe have a registered agent firm on the side, like our business. There could be instances where you are not a third-party filer. You prepare the information, but your client signs it and sends it in. And then there are situations all across the state where CPAs are acting in that capacity for their clients. So yes, it does.
Follow up.
Thank you, Mr. Chairman. So the way that I'm reading this bill right now, those CPAs would not be able to do those things because they're carved out in this bill.
Chairman,
Am I
through you.
misreading
Yes.
that?
I think that I understand the intent of the bill differently, and perhaps the Secretary of State's office can clarify that. My understanding is that CPAs and attorneys would still continue to be able to act as third-party filers. They would just not be required to register as such with the Secretary of State's office. And I don't see if there's
All right,
anyone here.
thank you.
Yeah, we missed them. Thank you.
And I just had one question. So in preparing anything, is it always a requirement that the CPA is the signator in turning things in, or is it ever done under another employee or another individual?
It would always be done by a CPA.
Okay, thank you. All right, any other questions? Thank you very much.
Thank you, sir.
Okay, is there anybody else in the room for public testimony? We will go to online. Matt, if you could let them in two at a time.
Mr. Chairman, I've admitted Pia Angelicus and Lucinda Wood.
Okay. Hello, if you could identify yourself, and I would say, since we have heard from attorneys, if you could limit your comments to something that we haven't heard already, but identify yourself and let's hear your testimony.
Sorry, volume is really bad. Can everyone hear me without the echo? Good afternoon, Mr. Chairman and committee members. My name is Pia Angelicus, and I am the Vice President of Government Relations for Cogency Global Inc. I'm here today to oppose Senate File 55 for many of the reasons that were already discussed, but primarily because it is overbroad and cogency is a registered agent. I'm sorry, I'm having difficulty with my volume here.
That's okay. I'm probably going to cut you short. We have your opposition, and I started to hear some.
I would like to point out that although the secretary indicated that the bill is intended for those that are signing documents, that is not the definition of a third party filer registration. The bill states clearly that the third party filer is a natural person who receives compensation to file documents.
Okay, thank you. Thank you so much for your testimony. Sorry about that feedback there. All right, next.
Hi, good afternoon, Mr. Chairman. My name is Lucinda Wood. I'm with Capital Services. And Pia got to the punch before I could that we don't necessarily oppose the legislation. We're, as was stated earlier, are partners with the Secretary of State, but we would like the statute to be cleaned up to really state what the Secretary of State means. If it means those who sign documents, it should say that in the statute, and it doesn't. It's not clear and consistent, as the Secretary said he wanted it to be. And that would be all. Thank you very much for your time.
All right, thank you for your testimony. Are there any questions? Okay, thank you. Next to Matt.
Mr. Chairman, we just have one more individual on this bill, Alan Statura. Mr.
Hello.
Statura,
Hi, yes.
please proceed.
Go
Hi,
ahead and
thank
introduce
you.
yourself, and we'll take your comments.
Sure. My name is Alan Statura. I am the chair of the Government Affairs Committee for the NPRA organization, and just wanted to really reiterate both Kelly's testimony as well as Lucinda and Pia's comments. Cleaning up the statute to make it say what is intended would absolutely be beneficial to all. And we believe that the proposed draft of the amendment that was submitted on behalf of NPRA would be quite helpful in regard to that, to making it be simple and clear and concise. And we appreciate your time in looking into that. Thank you.
Thank you very much. Any questions? All right, thank you for your testimony. With that, I will
Thanks.
close public testimony. Committee, what's your pleasure? Moved by Representative Brown, seconded by Representative Weber. Are there any amendments? Okay, no amendments. All right. We are taking roll call on Senate File 55. Matt, will you please take the roll?
Thank you, Mr. Chairman. This is a roll call vote on Senate File number 55, third-party filers. Representative Brown?
Aye.
Representative Locke?
Aye.
Representative Heft?
Aye.
Representative Johnson?
Aye.
Representative Lucas?
Aye.
Representative Webb submitted an absentee vote of aye. Representative Weber?
Aye.
Representative Yin?
Aye.
Chairman Knapp?
Aye.
Chairman, you have 9 ayes.
All right, with that, Senate File 55 does pass. Committee?
Mr. Chairman. So
Yes.
on this bill, I think that I'd like to figure out if we can get together with the secretary or with his designee at some point to see if some of that language can't be hashed out with the concerns that were brought before us.
All right, thank you. Thank you, Minority Leader Yin. I would agree with that as well. So, all right, next up. Senator, we apologize for bumping you, but welcome. We are on Senate File 107,
Is that mine?
Freedom to Work and Build Business.
Thank you, Mr. Chairman. Good to see you, House Corporations. Good representatives. Can you hear me okay? No?
Maybe just pull a little closer.
There we go.
Okay,
Better?
there we go.
All right, thank you. So you have in front of you a pretty significant policy change for you just to decide upon. And I want to make sure you understand what the question you're being asked to do, which is outlawing non-compete agreements. And what are non-compete agreements? Those are agreements that prohibit an employee from working from a competitor or starting a business in competition with their employer. So really significant policy decision in that historically I am for the freedom to contract, which means allowing individuals to determine their own terms of their own contracts and choose where they work and enter into those contracts freely. So why would I bring a bill that does such a significant policy change in adverse to that concept? Because it's actually doing the opposite of freedom to contract and a free marketplace. It's becoming more commonplace for employers to require employees to sign these agreements. And those are really impacting a significant members of Wyoming's workforce, primarily related to healthcare, but we see it in all professions. And it is interfering with the free market conditions that make a competitive business environment that are good for consumers, good for employees, good for a healthy workforce. So data indicates that 1 in 5 Americans are subject to a non-compete. 53% of those are hourly employees, and a third of those make less than $40,000 a year. So in Wyoming, we have seen from about 2021 to 2022, there were 4 Wyoming Supreme Court cases that came, which is a lot. And for about 20 years, there was just one Wyoming Supreme Court case that was the general law of the land that said non-competes were lawful so long as they were reasonable in what they did. Since that time, these cases continue to come before the court, and they have changed the law somewhat, but they're still lawful. So I want to talk to you about those cases because that's really the story of the bill, and I can be very brief, and I don't have anything else to speak on it. I could certainly bring a lot of people forward, but I know we're timely. So just imagine some of these nurses here with me if we can, Mr. Chairman, if
We
that's okay.
appreciate that. Thank you.
You're welcome. So in 2022, there was a home health care aide who worked for a company. So she's not a nurse, she's just an aide. And she worked for our company and provided services to a disabled child in someone's home, and she served others. She really built a connection with that child, and the family asked for her to work for them full-time. And she agreed, and she made like $12 an hour. The company she worked for, a very large company, sued her and took her all the way to the Wyoming Supreme Court to enforce that non-compete and her ability to provide care for that disabled child. So that's who it's impacting, starting with the family who needs special care for their disabled child, that they finally found a caregiver that they could trust, that they brought into their home to provide that full-time care, who is a $12 an hour employee, who she chose to make an opportunity where she could make a little bit more money for her family and care for this child consistently, and she gets sued all the way to the Wyoming Supreme Court. There was another case affecting a cardiologist, also in Wyoming, that went to the Wyoming Supreme Court prohibiting him from continuing to provide cardiology services in our state. Again, we need more cardiologists, we need more healthcare professionals, and so it really doesn't make sense to prohibit these types of professionals to be able to work. The other case involved another home healthcare nurse and her company, same situation, and the other one was for a salesman in Sweetwater County. And so even though those 4 cases, those actually reflect a significant number of other employees across our state that aren't coming to the Wyoming Supreme Court. They either just quit the employment opportunity they have and give up and just just choose to do something differently, leaving the occupations and professions for which they're valued or for which they serve. And I don't know that that's really working for the people of Wyoming, again, particularly as it relates to healthcare. The Wyoming legislature looked at this issue for a long time, and in fact, the bill in front of you was one that was worked by the Joint Judiciary Committee when I chaired it. And so that's where I actually pulled it from, knowing that we had did pretty good work. At that time, though, I wasn't comfortable as the chairman of that committee making such a significant policy decision. And so didn't actually pass it forward, and I was the vote that killed that. And I regret that, having seen significantly more of these even come into my practice and happening across statewide. So to walk through the bill, page 1, lines 14, going into page 2, lines 1 and 2. This is the bill, and it says, any covenant not to compete that restricts the right of any person to receive compensation for performance of skilled or unskilled labor shall be void. So that's the policy decision that we're making. Here are the exceptions, which I think are really important and provide the balance to such a serious prohibition. So the first one is a non-compete concerning the purchase of a business or the sale of a business assets. Totally different than the employer-employee relationship. And so if you sell your business to somebody, you can have a non-compete in there. The second one, found on lines 8 through 10, is trade secrets. So it's still lawful to require an employee to sign an agreement that says they won't reveal your trade secrets. So that's still secure. Lines 12 through 15, any contractual provision providing for the recovery of expenses for education or training, which we think is really important. The Senate amended this to up to 5 years, which I think is appropriate, whatever number is what you think is appropriate there. But this does allow for the recovery of a sign-on bonus or other investments that you have into an employee who then just leaves. You can have a contract that allows for that recovery, but it needs to say, the contract needs to say that. So it doesn't prohibit that ability to get that recovery for that investment. So another, I think, a good protective measure. Lines 17 through 19, it doesn't apply to executive and management personnel. So these are your CEOs, your high-level VPs. And the reason for this is they're in pretty sophisticated bargaining positions, and their contracts for employment generally look different than your standard employee who doesn't have a lot of bargaining power and doesn't have a unique employment contract. Then moving down on lines 21 through 23, this is important and it's fairly unique, and it's a provision concerning physicians and healthcare professionals who love to enter into the agreements like the cardiologist, where they enter into practice groups, companies, and so doctors will come together and form their own company. And then within that, they prohibit their partner from practicing in the area. And so we would restrict them from doing that. That said, they still would be allowed to collect any type of penalty from their partner. So partner, if you want to enter into business with me and leave, you got to pay $1 million, whatever they want to contract for, they still would be able to. They just couldn't prevent that physician from continuing to practice in the community. So they could have a really punitive response, but not blocking that physician from continuing to access patients or providing that service. And then moving on to page 3, paragraph C, this again relates to physicians. This provision actually relates to what are called solicitation agreements. Those are still lawful too, so we're not banning solicitation agreements where you can prohibit an employee from leaving your company and they can't then reach out to your patient or customer list and go solicit them. And this says those are still legal except for physicians who serve patients with a rare disorder. That those physicians need to be able to tell that patient with a unique disease, hey, I've gone to work over here and you can find me over here. Normally that would be considered a solicitation. So there's this carve out for physicians serving this particular very unique population. That's the bill. Happy to stand for questions.
Thank you, Senator. I had one, because I don't see this as too far off of a major policy change, because you're still allowing non-compete contracts to exist. It's just they were meant for proprietary information, the things that you listed, not necessarily a worker that is just doing their job for a pay and wants to go on to another job, basically. Is that correct?
It is correct, Mr. Chairman. I think also when I first started practicing as an attorney, one of the first clients whose contract I reviewed was a school lunch lady. She was in a school district here in the community, and she brought her contract because she wanted to take another job at another district for like 50 cents or $1 more an hour. You know, she also is making like $10 to $12 an hour at the time. And I thought, this is just ridiculous. This is not whom these are intended for. And it's just been abused in such a way. But for those, you know, CEOs and those, they can still do non-competes for them. But really to protect those workers in our state that are trying to advance and move ahead and seek career opportunities and to create a competitive free market environment, right? So I think that's also something to consider, that their inability to do that interferes with a free market.
I had one other question. So, you know, one aspect to non-competes, of course, is compensation. And I think that's one aspect that's been kind of perverted and misused and abused as well. Do you ever foresee having that written out in statute, or is that something that just contractually needs to stay in that contract?
Mr. Chairman, I think probably contractually should stay there, but it's certainly worthy of continued consideration.
Thank you. Yes, Representative Johnson.
Thank you, Chairman Knapp. Senator Nethercott, your provision for recovery of expenses, does that include, you know, the first year, if you work for somebody for 2 years, would that include their whole wages for that 2 years? How explain these steps to me a little bit better, please.
Senator Nethercott?
Sure, Mr. Chairman. So it's not automatic, but if there was a contract that that the employer said, hey, we want to bring you here, we're going to pay for your moving expenses, and we're going to pay for a semester of college, whatever it might be. But if you don't stay for 3 years, whatever that contract is, you have to pay that back. But it would never be your wages. It would be like that sign-on bonus or some type of training or education that employee would receive before the employer could receive the benefit of time with that.
Follow up?
So, thank you, Chairman Knapp. This would not include on-the-job training then? It would be a specialized educational.
Senator?
Mr. Chairman, correct.
Any other questions? Okay, thank you.
Thank you.
Is there anybody here, elected officials or public, that wants to speak on this issue? No? All right. Anybody online, Matt?
Mr. Chairman, no.
Okay, we'll close public testimony. Committee, what's your pleasure? Representative Weber, I just elevated you. With the motion, Representative Lucas with the second. All right, any amendments? Yes, Representative Weber.
Thank you, Mr. Chairman. After hearing from the good senator and explaining the bill, I think the title of this would be better suited to state non-compete agreements prohibited. And I would ask for that amendment and seek a second.
Okay, it's been moved and seconded.
Mr. Chairman,
Yes.
just for clarification, is the amendment to replace the entire catch title or to add to the end of the catch title?
Representative Weber.
Thank you, Mr. Chairman. Mr. Minority Floor Leader, it would be to change the catch title up on the very top, freedom to work and build business. Change that to non-compete agreements prohibited.
All right. Discussion on the amendment. And Senator, I'm gonna go ahead and get your comment on that if you would.
Whatever the committee's wish.
Okay, thank you. All right, we have a amendment on the table to change that to non-compete agreements prohibited. Representative Lucas?
Thank you, Mr. Chairman. I just wanted to clarify, so does this bill prohibit non-compete agreements then?
I believe it,
Or
I believe it
There's some
would.
limitation.
I would believe it,
Okay.
it does to those workers who just are
Okay,
salaried workers or per hour workers that don't require necessarily a non-compete,
doctors.
so.
Yeah, okay. Thank you.
All right, all those in favor of the amendment signify by saying aye. Aye. All those opposed, no. That amendment does carry. Any other amendments? Okay. Matt, would you please poll the board or the committee on Senate File 107
Thank you, Mr.
with
Chair.
amendment?
Yes. Thank you, Mr. Chairman. This is a roll call vote on Senate File number 107, Freedom to Work and Build Business by Amendment renamed Non-Compete Agreements Prohibited. Representative Brown?
Aye.
Representative Locke?
Aye.
Representative Heft? Representative Johnson?
Aye.
Representative Lucas?
Aye.
Representative Webb?
Aye.
Representative Weber?
Aye.
Representative Yin?
Aye.
Chairman Knapp?
Aye.
Chairman, you have 9 ayes.
With that, Senate File 107 does pass the committee. Thank you, Senator. All right. Matt, do we have one more bill?
Mr. Chairman, yes, we have Senate File 57, 9/11 service reporting.
I think what we'll do is, we have one more meeting upon recess, or upon adjournment, I'm sorry. And we'll move this over to that so we can get back to the floor. That's okay with committee? All right, any other business? With that, we are adjourned. Yes.